Hello and welcome to Win Without Law School. Today we are going to talk about creating a case strategy for legal decision-making and parenting time. I'm Arizona lawyer Julie LeBenz. Thank you so much for joining us today. In today's session, we are going to cover many different aspects of legal decision-making and parenting time. First, we're going to talk about why create a case strategy, how that is helpful to you in a case. In part two, we're going to talk about Arizona's legal decision-making laws. In part three, we're going to talk about joint versus sole decision-making and how to decide what to request in your case. In part four, we're going to talk about parenting time laws here in Arizona. And finally, about how to create a parenting time proposal in your case. All right. Why should you create a case strategy for legal decision-making and parenting time, and where do you start? Well, the case strategy helps you get clear about your desired outcome. So it's not just like, oh, I want the kids most of the time. Like you want to actually have a proposed schedule, because number one, that puts you in a position to negotiate. If you don't have a requested outcome, then how are you going to engage in negotiations? How are you going to make a settlement proposal if you don't have a position? Also, if you're going into court, the judge is going to want to know what you want. So creating your case strategy is really important. And also, you can start to put together your position and then also start to analyze, is this reasonable or not? Am I asking for a non-50-50 parenting plan, and is that reasonable in the circumstances or not? Am I requesting sole decision-making? Is that merited here? Once you start to figure out what you want, you can start determining if your requests are reasonable under the law, or if maybe you need to be a little bit more flexible with some of your requests. Now, as far as a case strategy for legal decision-making, your strategy is going to be asking for joint or sole, and there can be a bit of a hybrid of the two, and we'll talk about how to do that. And then for parenting time, you want to create a detailed year-long parenting plan proposal, and the more details, the better. All right, let's get into what Arizona law has to say about legal decision-making. We're going to talk about what it is. We're going to talk about what joint legal decision-making is, as well as what sole legal decision-making is. Now, there's a lot of confusion about legal decision-making. A lot of people think it's much broader than it actually is. However, it is technically making legal decisions about your child's education, healthcare, religion, and personal care decisions. So it's not, that covers a lot of area, but it's not necessarily everything. It's these set designated areas. Legal decision-making can be joint or sole. So for joint legal decision-making, both parents share decision-making, and neither parent's rights or responsibilities are superior, except with respect to specified decisions as set forth by the court or the parents in the final judgment or order. Judges generally start with a presumption that joint legal decision-making will be ordered, and will only order sole legal decision-making if it's justified in the circumstances. And we'll talk about some of the circumstances where sole legal decision-making is justified. If you're considering, if you're on the fence between sole and joint, one thing to think about is these actual categories. So for example, education. If your kids are going to, certain schools, and they're going to keep going to those schools, and there's no dispute over that, then joint decision-making on education likely makes complete sense in the case. Same thing with healthcare. If there's no really special healthcare needs for your kids, and they've been going to the same doctors and dentists their whole life, and they're going to keep doing that, and no problem. Religion, usually the court is like, look, even if you have different religions, then dad, you do your religion during your parenting time, mom, you do yours during yours, and they generally will resolve it that way. And then personal care decisions, that's haircuts, clothing, getting your ears pierced, it's stuff like that. And usually those are things that parents can work out between themselves. Education and healthcare can be where there can be bigger disputes. But in general, if you don't have major disputes over those 4 categories, then joint decision-making would likely be a good fit. For sole legal decision-making, this means one parent has the legal right and responsibility to make major decisions for a child. So with sole, it's just going to be one parent making the decisions. They still will need to provide information and keep the other side informed. They don't get to conceal information from their co-parent just because they have sole legal decision-making. It's just they don't have to consult and get their permission first before they make the decision. Now, you and your co-parent have the option to agree to joint legal decision-making with one co-parent having final say on education and or healthcare if there is a dispute. Now, I left out religion and personal care decisions, although you could do the same thing on those. I highlighted education and healthcare because that's usually where really important decisions need to be made. And so if the 2 co-parents can't agree, there can be language written into the parenting plan saying, look, we have joint legal decision-making, and we're going to discuss all legal decisions about education for our children. But if we reach an impasse and we can't agree, then dad has final say or mom has final say. You can craft an agreement like that. Another option is to rely on a trusted healthcare professional and have them make the decision if you're at an impasse. So that's an option. So you can agree to have these carve-outs for certain areas. So the difference between the first and the second point is that you have joint, but you just name one parent to have final say, or you can have joint decision-making on certain issues and sole legal decision-making on certain issues. So those are some options. Overall, you and your co-parent can craft a procedure to follow in the event you reach an impasse on a legal decision for your children. For example, if you reach an impasse on healthcare, you could name a trusted doctor that your child has seen for many years and say, we're going to go with whatever the doctor's recommendation is. That's one way to break the impasse. Overall, these things are important because you're not necessarily going to have the time or resources to go to the court anytime there's a dispute about one of these legal decision-making issues. So, for example, if you're fighting over where your kid's going to go to school and the enrollment period is coming to a close, you may not be able to get court relief that fast. So having some provisions in your parenting plan that explain what is going to happen if you can't agree can be helpful, or naming, a final decision maker to just make the decision. That can all be really helpful. All right, let's talk about how to choose between joint or sole legal decision-making when you're creating your case strategy. Number one, what's best for your children? I mean, that's what the standard is in the law. That's what the court's going to be looking at. What's best for your kids? To have both parents making the decisions together, to have one parent making the decision, or to have some hybrid of the two? Are you and your co-parent in agreement regarding your children's education? If you are, then joint decision-making makes sense. Are you and your co-parent in agreement regarding healthcare for your children? If so, joint makes sense. Do you or your co-parent practice an obscure or controversial religion? That is where this, maybe having sole on religion can be a more compelling argument, because like I mentioned earlier, if you have different religions, let's say one parent's Catholic and the other is Jewish, the court will say, look, well, when the kids are with the Catholic parent, practice Catholicism. When the kids are with the Jewish parent, practice Judaism. But then you have a religion like Jehovah's Witness, where they have such different rules. There's healthcare you're not supposed to get. There's holidays and birthdays you're not supposed to celebrate. And that's when the rubber can meet the road, and you might need a clear sole decision-making order for religion, for education, for healthcare. So depending on the religion, and if it's obscure or controversial, that's when the court may pay more attention to differences between the co-parents' religious beliefs. Finally, has there been domestic violence, child abuse? How effectively are the parents able to communicate about their children? Substance abuse, all of those things come into play, and we're going to get into those details more. But If the parents just can't communicate well at all, that can be a persuasive argument for sole decision making or to have one parent have final say. The court doesn't want you coming back, all the time to get the court to make these decisions for you. They want the parents to figure out a way to work together in the best interests of their children. So parents don't agree on legal decision making. What does the court do at that point? Well, the matter would proceed to a trial. And at the trial, the court's going to be looking at these statutes. So first we have this 25403.01, and it directs the court, this is subsection B, and it says, in determining the level of decision making that is in the child's best interest, the court shall consider the factors in 25403A and all of the following. Number one, the agreement or lack of agreement by the parents regarding joint legal decision making. So why aren't the parents agreeing? Is their lack of agreement unreasonable? Is it influenced by an issue not related to the children? Also looking at the past, present, and future abilities of the parents to cooperate in decision making about the child to the extent required by the order for joint legal decision making. So what the law is saying here is you don't necessarily have to agree on everything, past, present, and future, but if you have the ability based on what you've shown in the past or the present and to cooperate enough for joint legal decision making, then the court is going to consider that. Finally, whether joint legal decision making is logistically possible. So if you have one parent with the child in Arizona and the other parent lives in New York, joint decision likely isn't logistically possible just because of the distance involved. So that alone can be a persuasive argument for sole decision making if it's not logistically possible. So in looking at sole versus joint, the court is going to analyze these 4 factors. So these are 4 factors that you want to present evidence on when your case goes to trial, if this is a big disputed issue in your case. And then you're also going to want to present evidence about the best interest standards, which are in 403A, and we'll talk about those as well. So 403A, this is where the court is going to weigh a bunch of different factors and use those to decide what's in the child's best interest. We've got a question here. Can certain areas of decision making maybe assign certain areas to each parent? Yes, you can do that. It's just a matter of reaching an agreement and getting the specific details into your final order. But yes, the parents can get very specific about who's going to make what decisions, how information is exchanged, what decisions they'll make mutually. All of that can be discussed and agreed upon by the parents if they're able to do so. Okay, so 403, these are factors, and this is going to play into both legal decision-making and parenting time. You can see here the court looks at legal decision-making and parenting time in accordance with these standards. And the court is supposed to look at all relevant factors, including these standards. Number one, the past, present, and potential future relationship between the parent and the child. So if you're arguing for sole legal decision-making on healthcare, then you're going to want to be presenting evidence about how in the past was healthcare dealt with, and how in the past did these decisions go? Because if you're able to show, look, my co-parent was advocating that our child not go to school and just stay at home all day and watch TV, and obviously we can't have him be making legal decisions about our child's education. This is where you can bring in evidence to support your request. Number two, the court is going to look at the interaction and interrelationship of the child with the child's parents, siblings, and anybody else who may significantly affect the child's best interest, the child's adjustment to homeschooling community, if the child is of suitable age and maturity, the wishes of the child as to legal decision-making and parenting time. Regarding a suitable age, 8, 9, 10 and up, and children can't testify. So in determining the wishes of the child, it's either going to be the parents testifying, telling the court what they believe the child's wishes are, or the court can do what's called an in-camera interview and interview the child to see what their wishes are. An in-camera interview needs to be requested by one of the parties through a motion, and it's up to the court whether the judge grants it or denies it. In my experiences, it's tough to get an in-camera interview request granted. It really depends on your judge. Number 5, the mental and physical health of all individuals involved. And number 6, which parent is more likely to allow frequent, meaningful, and continuing contact between the child and the other parent? If one parent has withheld the child, then paragraph 6 doesn't apply if they withheld the child so that the child didn't witness or be a victim of domestic violence or child abuse. Number 7, whether one parent intentionally misled the court. Number 7 can be really tough to prove. I've made the allegations in several cases, but it's tough to prove. Number 8, if there's been domestic violence or child abuse. Number 9, the nature and extent of coercion or duress used by a parent in obtaining an agreement. Whether the parents have taken the parenting class, whether there's been a conviction for false reporting of child abuse or neglect. And the court is supposed to make specific findings about all of these issues. So we have a question about, is emotional abuse at issue? And yes, the court will consider emotional abuse. Now, you're going to want to have evidence of it. Just throwing that term out isn't persuasive. But, my co-parent emotionally abuses our son, and let me give you some examples. I've taken my son to a counselor. Here's the counseling records documenting the emotional abuse that dad has inflicted, or whatever. Gender isn't the thing. I'm just throwing out examples. But yes, emotional abuse is an issue the court will look at, but you're going to need to give facts and examples. You can't just throw the term emotional abuse out there and think that that's going to be enough. So just to kind of bring this full circle, I know that there's a lot of factors here and it's kind of confusing, and it is, but what we're looking at here is if you have a contested legal decision-making case. So one parent wants sole decision-making either on all the categories or a couple of them, the other wants joint or vice versa. These are some of the considerations the court is going to look at in resolving that dispute. And that means that this type of evidence you would be presenting at the trial where the judge made that decision. So really what we're looking at, here is using this to support your request. Okay, so if you're saying sole, these are some of the guidelines to start, some of the parameters to start gathering evidence in your favor. The same thing if you're requesting joint. Now we've got a couple of questions here. Number 1, we have a question about, is this turning into, if this goes to trial, are we looking at this battle of who's the better parent? Yeah. I often call custody trials the politics of personal destruction. I mean, you're in there and you're just throwing mud at each side. And yeah, it can turn into this better parent battle. And if you are in that dynamic, you're really going to want to think about your judge. What is going to be compelling to the judge? Because little nitpicky things back and forth and, she got the kids to school late one day and she forgot to feed them lunch one day. I mean, if you can get like 10 things together, those could all add up to be compelling. But if you're just like, she got the kids to school late one day, like that's not that compelling. So you really need to weigh your evidence and organize it so that it's persuasive. We've got another question. Do recordings help during transition when the child is crying due to parental alienation, such as the other parent commenting that the child doesn't want to be with the co-parent? There's also prolonging goodbyes to make transition harder. So the transitions, prolonging goodbyes to make transitions harder. If you can set up your transitions to happen through school, that can be really helpful in changing up this dynamic, because then one parent drops the kid off at school, and then the other parent picks them up to start their parenting time. And so the parents aren't actually seeing each other at the exchange. So if that can happen through school, through extracurricular activities, through a sporting event, something like that, that the kid is involved in, that can be helpful in addressing this transition issue. As far as recordings, if you're looking to take this issue to trial, you're looking to take this issue to court to show that the parent's violating your parenting plan or not acting in the best interest of the child, the recordings could be evidence to help support your position. But that could be made stronger with some sort of counseling records, something else from a neutral third party to justify this allegation of parental alienation. And of course, you're going to be looking at this at the bigger picture of what is my requested relief? It's one thing to prove that you've been alienated, but what do you want to get out of it? Do you want more parenting time? Do you want the other side to have to pay a fine? Do you want them to have to take a parenting class? Do you want family counseling? You're going to have to really look at what is your requested outcome and then kind of work backwards to see how you can potentially accomplish that. Okay, let's continue on with some of these statutes. What we're looking at here, just to get back to where we were, is we're looking at parts of the law that allow the court to award sole legal decision-making. And so we're looking now at domestic violence and child abuse. So if the court finds by a preponderance of the evidence that there's been significant domestic violence or a significant history of domestic violence, then the court's not supposed to award joint legal decision-making. If the court determines that a parent seeking sole or joint legal decision-making committed domestic violence against the other parent, there's a rebuttable presumption that an award of sole or joint legal decision-making to the parent who committed domestic violence is contrary to the child's best interests. So what we see here between A and B is that under A, if there's significant domestic violence or a significant history, then the court should order sole decision-making to the victim of domestic violence. If there's been an act of domestic violence, just, one act, not the significant history, not the significant domestic violence pursuant to law, but an act, then there's a rebuttable presumption. So it means there's a presumption that the victim of the domestic violence should get sole legal decision-making. However, the other parent can seek to rebut that presumption by presenting evidence that they've been rehabilitated and that they're not going to act in a violent way going forward. So what the court looks at regarding this act of domestic violence is the court looks at, did the co-parent intentionally, knowingly, or recklessly cause or attempt to cause sexual assault or serious physical injury? Did they place a person in reasonable apprehension of imminent serious physical injury to any person? Did they engage in a pattern of behavior where an ex parte order of protection could be issued? So when under this subsection D, when we're looking at the definition of domestic violence, it is more limited. It's not the whole broad, huge domestic violence. It's this defined domestic violence, which raises that rebuttable presumption. So we've got a question here about how do you get family counseling ordered just based on the children's behavior? So first of all, keep in mind that counseling doesn't have to be family counseling. It can be counseling just for the children. And having joint decision-making doesn't necessarily mean that you need both parents' signatures to get the children into counseling. That's usually going to be determined by the counselor's office. You'd have to talk to your selected counselor and see if they require both parents' signatures on their, their forms that they have you sign all their agreements. So you can look at counseling for the kids. And then, of course, if the counselor starts finding that the other parent is toxic or is causing emotional abuse, that can go into the counseling records, and those could then be used at trial. But I think that your question is worded correctly in that the focus of a request for counseling or the focus of a reason to proceed to counseling is really looking at the kids, not, being mad at the other parent or blaming them, but saying the kids need this. That can be very persuasive versus some sort of argument about, the other side they need counseling or something like that. And you don't have to do family, but you can say, we just need to get the kids in counseling and get them some help. Okay, we've got another question. I understand toddlers have accidents, but does a judge look at bruises on backs, cheek, as well as sunburns without proper care? A Department of Child Safety intake has been done, but since my son is 2, I just have pictures since he is just learning to speak in full sentences. Yes, a judge will definitely look at bruises, sunburns, document it. You need the pictures. You want the date and time. You want to show that the kid just came from dad's. You're going to need to set up the full explanation. This is when he was with dad. This is the picture I took when he got home. Here's this bruise. Here's this sunburn. Here's his teeth not brushed. Here's his clothes that are dirty. Here's the dirt, whatever all of that is. And continue to document it, because just one instance, the other side could potentially say, oh, I learned and I've changed and But if you can show repeated instances, that's really important. Also, depending on the type of injuries you're finding to your son, going to urgent care or some sort of medical provider to get a medical report written to substantiate your allegations and to show the actual abuse, that can be really helpful too, because then it's not, some allegation, oh, she distorted the picture and that's photoshopped and that's not accurate. If you have some third parties like DCS or a medical record, that can be helpful in substantiating the abuse. And yes, a judge is definitely going to look at that, but you got to present it to the judge. Okay, back to DV and child abuse. And of course, you're talking about child abuse, that can be grounds for sole decision-making in addition to the majority of the parenting time. All right, so what we're looking at here is if you don't have significant domestic violence, you don't have a significant history, but domestic violence has occurred and it fits within one of these 3 definitions. And so how then can that be rebutted? Meaning the parent who is accused of committing the domestic violence, how can they show that they've been rehabilitated and that they should get joint decision-making? So they could show that that's best for the child. They can show that they completed a DV course or a alcohol or substance abuse counseling, that they completed a parenting class, if they're on probation, parole, or community supervision, whether they're restrained by a protective order, and whether they've committed any further acts of domestic violence. So if you've got a case with DV, there's a lot of complication in that statute, but the takeaway is that if you can prove domestic violence, then that can entitle you to sole legal decision-making and more parenting time, or that the other side's parenting time be supervised. Let's talk about substance abuse. So we talked about domestic violence and child abuse, but then what if your co-parent is abusing alcohol and or drugs? If the court determines that a parent has abused drugs or alcohol or has been convicted of any drug offense or DUI within 12 months before the petition for legal decision-making or parenting time is filed, there's a rebuttable presumption that sole or legal decision-making by the parent is not in the child's best interest. So number one, if your co-parent has a conviction that's related to drugs or alcohol within the past year, when you're filing your papers, that can be an allegation you can make, and that can entitle you to sole decision-making. However, we've also got this part. You don't have to have a conviction. You can also show just the abuse of drugs or alcohol through separate evidence. So you could have a spouse that's abusing drugs or alcohol, but doesn't get caught. but you can present evidence to support your allegation that they're abusing drugs and that as a result, they shouldn't have joint decision-making. So the court is supposed to look at findings of fact that support the determination that there's been drug abuse or a conviction. Findings that legal decision-making or parenting time is appropriate, like there's certain facts in place that protect the child. So it's a rebuttable presumption, and if the court is going to award the joint, the court needs to find why that's okay and how the child's going to be protected. The court is going to look at the absence of any conviction of any other drug offense during the previous 5 years. The court can order random drug testing. And then results of drug screening, the court can use that as well. All right, now if your co-parent is a sex offender, either before you establish custody, or let's say you've got custody papers in place and then they get charged with a sex offense. Unless the court finds there's no significant risk to the child and states its reasons in writing, the court shall not grant a person sole or joint legal decision-making or unsupervised parenting time if they're a registered sex offender, they've been convicted of murder in the first degree, and the victim of the murder was the other parent of the child. And then, that's a pretty narrow situation, but there's some other evidence the court will look at in that circumstance. A child's parent or custodian must immediately notify the other parent if they're going to bring the minor child around a convicted sex offender. So keep that in mind. There is a notification requirement. Not quite sure why you'd want to bring your kid around a sex offender. Of course, some people can have that sex offense and then be rehabilitated, and maybe it's a family member or something, but you do need to give notice to the other side if you're going to do that. All right, we've got a question. What if the parent uses a breathalyzer for a past DUI, but has been witness driving 2 different vehicles? So, what you're trying, that's important. Of course, you would need to bring the other witnesses to court to testify to seeing him drive other vehicles. Under really what that evidence would go to prove is that your co-parent is someone who will ignore court orders. The court doesn't have jurisdiction to punish your co-parent for potentially violating part of their DUI criminal order. But that is valid evidence to show this is a person who doesn't follow court orders, and that could be compelling to the court. If that past DUI was within 12 months, that can be alleged as grounds for sole decision-making. And, the fact that they have a breathalyzer in their car, of course, that tends to show that they may or may not drink and drive with the child in the car. Of course, you have this evidence that they're driving without the breathalyzer at times. But the breathalyzer isn't the end all be all. That's just for driving. What about when they're at home during parenting time? That's where just because they have a breathalyzer in their car doesn't mean that they're sober during their parenting. And there is some new devices that you can buy where there's a little breathalyzer that can be used before and after parenting time. So it's called SoberLink. And so it's a device, the parent has to blow into it. It gives a BAC that gets, it's all connected. And so that information gets sent through the cloud and it's kept in a database. And then at the end of their parenting time, blow again. So, you can have proof of sobriety during parenting time using the SoberLink. And that is something that judges are utilizing versus just no parenting time at all, saying, okay, well, you can have some parenting time, but you're going to need a test before and after. And if you violate, then your parenting time's forfeited. Okay. All right. So we talked about sex offenders. All right. There's also this statute about access to medications and records, which these are some important points to just be aware of. Okay. We've got one other question here. Can you put requirements on the counselors, evaluators, or anybody? Mental health professionals who are assessing in just a second. So what you're looking at, your question is, do you essentially have any say on counselors, evaluators, or any third parties who are going to turn this on, who are going to spend time with your children or write a report in your case or anything like that? So I think, we need to break this down. Number one, is this being ordered by the court? If it's being ordered by the court, then you generally get to propose somebody for the court to order. The two sides would get to, and then the judge would make a final decision. Other times, the courts will just order somebody that's on like their list. But if you're doing this outside of a court order, like you are trying to gather information, so you're going to a mental health professional and having an assessment done, then you would get to choose that professional and could, make sure that they have the proper qualifications. Overall, if it's something where you and your co-parent each get to make a recommendation, then I would be looking to see who did they recommend and do they meet your standards? And if not, making an objection to the other side's recommended professional based on them not having sufficient qualifications. Okay, all right, so unless otherwise ordered by court order or law, on reasonable request, both parents are entitled to have equal access to prescription medication, documents, and other information concerning the child's education and physical, mental, moral, and emotional health, including medical, school, police, court, and other records directly from the custodian of records or from the other parent. What this means is that even if one parent has sole legal decision-making, they don't get, a monopoly on the records. Instead, it doesn't matter if it's sole or joint decision-making, both parents have equal access to medical and educational information about their children. And they can either get that directly from the other parent or from the custodian of records. So for example, if you wanted to get prescription medication information about your child, you could go to the pharmacy that issued the prescription and get it from them, or from the medical provider that issued the prescription. You'd be able to get that directly from the provider or from the other parent. A person who does not comply with a reasonable request for this information shall reimburse the requesting parent for court costs and attorney's fees. A parent with joint legal custody shall not designate one pharmacy in a single location as the only source of the child's prescription medication without an agreement from the other parent. A parent who attempts to restrict the release of documents or information by the custodian or attempts to withhold prescription medication without a prior court order is subject to appropriate legal sanctions. And then there's also this 25408K, which explains that each parent is entitled to have access to prescription medication, documents, and other information about the child, unless the court finds that access would endanger seriously the child's or a parent's physical, mental, moral, or emotional health. So although the starting point is equal access, if you have reason to believe that allowing equal access to these records is going to harm you or your child, you can ask the court to enter an order prohibiting access. All right, let's talk about 25-40307. See if we got a question here. Just a second. Okay, we have a question about using a communication tool like My Family Wizard as part of the plan obligation. Yeah, oftentimes co-parents will agree to use these online programs like My Family Wizard. There's several options out there these days. With each option, usually the biggest factor is the cost, because some are low cost, some are no cost, some are a little more per month. So the cost is usually a big deal, but it's nice. It allows all your communications to be in one place. There's also these tools that calm down the communication so that the exchanges are actually more respectful. And you can also upload documents and share them in there. So I haven't gotten complaints about those tools. I've found that a lot of co-parents prefer that versus just texting and email or face-to-face communication. Okay, the court may specify one parent as the primary caretaker and one home as the primary home for the purpose of defining eligibility for public assistance. This finding does not diminish the rights of either parent and does not create a presumption for or against either parent in a proceeding for the modification of legal decision-making or parenting time. So just if you are receiving public assistance, it can be important to get identified as the primary caretaker and as the primary home in your final court orders. All right. How does child support play into this? Now, we're just going to look at a small part. We're not going to go deep into child support today. But for any parenting time order entered under this article, under Article 4, the court shall determine an amount of child support. So if you're establishing legal decision-making and parenting time, the court is going to automatically look at child support too. And an award of joint legal decision-making or a substantially equal parenting time plan does not diminish the responsibility of either parent to provide for the support of a child. Now, having substantially equal parenting plan, in particular, if you have substantially equal incomes, can result in a zero child support obligation, but you would have to run a child support calculation to see how the numbers fall. Okay, I believe this is the final statute in this section, but just one other consideration: if a person has been convicted of sexual assault and the sexual assault led to the birth of the child, the convicted person has none of the rights for legal decision-making or parenting time. So I've never had that come up in a case, but it's interesting. So essentially, if there was a rape and a child was conceived via the rape, the rapist is not entitled to legal decision-making or parenting time rights under this statute. All right, let's get into parenting time now. So, we talked about legal decision-making and we're looking at sole versus joint. The starting point for the court is going to be that joint legal decision-making unless you have facts that justify a sole decision-making order. And you can potentially do a hybrid of, we have joint on this, we have sole on or I have sole on this decision, or you can also designate one parent to have final decision-making. All right, that's legal decision-making. Now let's talk about parenting time. Parenting time statutes. First of all, what is parenting time? Well, it's the schedule of time that each parent has access to a child. And during their scheduled parenting time, the parent is responsible for providing the child with food, clothing, and shelter, and may make routine decisions concerning the child's care. So that's what parenting time is. An order for sole legal decision-making does not allow the parent designated as the sole legal decision-maker to alter unilaterally a court-ordered parenting plan. So legal decision-making is just education, healthcare, religion, and personal care decisions that it doesn't give you authority to do anything else. So the sole legal decision-maker is just on those issues, but it doesn't give you power to unilaterally alter a court-ordered parenting plan. Also, a parent who is not granted sole or joint legal decision-making is entitled to reasonable parenting time to ensure substantial, frequent, meaningful, and continuing contact with their child, unless it's proven that parenting time would endanger the child's physical, mental, moral, or emotional health. So aside from the sole or joint legal decision-making determination, the court is supposed to grant reasonable parenting time to allow substantial, frequent, meaningful, and continuing contact between the parent and the child. But the court is not obligated to give reasonable parenting time if you show endangerment to the child's physical, mental, moral, or emotional health. All right, now we're going to look at 403.02. This is the statute on parenting plans. So this tells you what to include in your parenting plan. You need to include, if the parents cannot agree on a plan for legal decision-making, then you need to submit a proposed parenting plan. B, the court shall adopt a parenting plan that provides for both parents to share legal decision-making and that maximizes their respective parenting time. The court shall not prefer a parent's proposed plan because of the parent's or the child's gender. We've got a question here. Okay, so the question was, how does the court determine those things? Can you clarify what you mean by those things? Okay, so on the last slide. Let's see if I can go back. Okay, so I think what you're saying is, how would the court determine endangerment to the child's physical, mental, moral, or emotional health? I believe that's where you're going with this question. Well, endangerment to physical health, that would be kind of like that question that came up earlier. Evidence of bruises, sunburns were mentioned, injuries, any sort of physical abuse, you're going to want to document through DCS reports, medical reports, pictures, a timeline, all of that. Endangerment to a child's mental health. You're likely going to need some sort of third-party evaluation to really prove that point. Some sort of counselor, a teacher, somebody who is concluding, yeah, mom or dad is causing serious endangerment to this child's mental health. Maybe, you have some evidence like, oh, since the child started spending time with mom, the child had to go on antidepressants and started cutting themselves and, it started having suicidal thoughts. You want to get into the details about what's going on with this child and how the parent is causing the endangerment. Endangering moral health, certainly that one can be a little bit more difficult, but what if the parent is exposing a young child to pornographic material, or has a new girlfriend or boyfriend and is being intimate with them in front of the child? Those are things that come to mind under the moral umbrella, but keep in mind this is going to be endangering moral health. So this is going to be a serious thing, not just, dad lets the kid watch TV and mom doesn't. Mom thinks TV is bad for the kid's moral health. Dad, that's not enough versus, pornography or something that's really clear cut. So keep that in mind. And then emotional health, same thing. You're going to need to have some specific facts about how parenting time is negatively impacting this child's emotional health. Is the parent teaching them to lie? And now they're turning into a liar. Of course, proving these things can be difficult. And so you're really going to need to get clear on what is your case and how are you going to prove that? And then put yourself in the judge's position and think, what would be compelling to a judge here? And those can be some good starting points. Okay, so we're talking about parenting plans. And this is what the court wants in a parenting plan. Number one, whether legal decision-making is joint or sole. Number two, each parent's rights and responsibilities for personal care of the child and for decisions in areas such as education, healthcare, and religious training. Number three, a practical schedule of parenting time for the child, including holidays and school vacations. Number four, a procedure for the exchanges of the child, including location and responsibility for transportation. A lot of parents approach a parenting plan way too broadly. Like when they first get started, they're just like, oh, well, we'll figure out what time and we'll figure out the location. And, she can have them a few days a week and I'll have them a few days a week. And it's just, if you're going to leave it that broad, you're going to have to communicate with your ex constantly to iron out all the details. So it's instead, if you don't want to have that much contact and entanglement, then you want a very detailed schedule. What is the exact days the child will be with mom? What are the exact days the child will be with dad? Where do the exchanges take place? What's the exact time? Who does pickup? Who does drop off? All of that should be in your plan. And like we talked about earlier, if you can organize to have the exchanges happen through the school, that can be great. So let's say you have a week on, week off plan. It ends Monday morning. The parent ending their time drops the kid off at school. The parent starting their week picks the kid up from school, or the school bus brings them to their house, whatever. And then their week starts, and then it switches on Monday with the exchange happening through the school. So that can be nice because then there is not, constant contact between the parents. There's a question, how long in detail can the plan be? As long and detailed as you'd like. Of course, the other side needs to agree, but yeah, some people do very detailed parenting plans that are 20 plus pages. You can get really into the details. Number 5, a procedure by which proposed changes, relocation of where a child resides with either parent, disputes and alleged breaches may be mediated or resolved, which may include the use of conciliation services or private counseling. So the court wants you to already agree at the outset about what you're going to do if you have a disagreement about parenting time or legal decision making. And often something people agree to is that you'll try mediation first. That is a potential option. You could put terms in there that you'll sit down together and try to work it out first. If that doesn't, then you'll go to a mediator. If that doesn't, then to the court. Sometimes there isn't enough time to go through all those steps. So you can also include language allowing you to go straight to the court in certain circumstances. Overall, the point is, can you put together a plan to seek to resolve disputes so that you're not running back to the court every time you have a disagreement? Number 6, a procedure for periodic review of the plan's terms by the parents. So the court recognizes that, the plan is going to change as things change with the co-parents' lives and as the children get older and their schedules change. So every year, every 2 years, every 3 years, the parents can agree to get together and review the plan and see if they are in agreement with any changes. Number 7, a procedure for communicating with each other about the child, including methods and frequency. So this is where you could agree to use one of the online services like My Family Wizard, or you could say, look, we're only going to text. It's only during these time frames, or we're only going to email, or whatever terms you're comfortable with for communication. Also, you can include terms about how the parent communicates with the child during the other parent's parenting time. So for example, you could have a set phone call at 7:30 every night for 30 minutes during the other parent's parenting time and vice versa. A lot of kids have their own cell phones and stuff these days. So setting up a set time is probably more relevant to younger children that don't have, their own phone. But setting up a set time for communication during the other parent's parenting time can be really great. Because if you don't have a set time, the other parent could potentially call all the time, and that can be really disruptive. So having a set time can give everybody some certainty about when communication will unfold. If the parents are unable to agree on any element of their parenting plan, then the court will decide. The court may determine other factors that are necessary to promote and protect the emotional and physical health of the child. Shared legal decision-making does not necessarily mean equal parenting time. So you could have joint decision-making, but you don't have to automatically have equal parenting time with that. All right, let's talk about how to create a parenting plan proposal. Your plan should be a year long. Propose when the children will be with each parent during the school year, the summer, and the school breaks and holidays. So that could be one way to start breaking this down. And usually starting with the school schedule is the easiest. So figure out what you want to happen when your kid is in school. And then consider the summertime. Okay, when they're out of school, and it's generally about 2 months, kids go back to school in August now. So June and July, you're looking at 2 months. Do you want to follow the same schedule? Do you want it to be different in the summer? And then looking at the school breaks and holidays and seeing what you want for that. Propose times for pickup and drop off, propose one or more locations for pickup and drop off, designate who's responsible for the pickup and drop off. Consider using your children's school as the exchange location to minimize contact. Propose how the parents will communicate with each other and with their children. So we talked about that. Here's some special considerations when crafting a parenting plan proposal. Do you have a short distance or a long distance parenting plan? Long distance is generally over 100 miles apart. But of course, even if you're 20 or 50 miles apart, you still are going to have a different parenting plan. So short distance or long distance? And then for the long distance, how far away are you? Are you both in Arizona, but in different parts? Or does it require a plane ride? So really looking at what type of schedule, long distance versus short distance. Create your proposed school schedule and look at what happens for 3-day weekends, the spring break, the fall break, and the winter break. Some people keep the schedule the same no matter what and just let the breaks fall where they may, in particular for 3-day weekends. Other people make specific changes for those 3-day weekends and the spring break and the fall break and the winter break. Create a proposed summer break schedule. This can be the same as the school schedule, of course, with the kids not being in school, or you can have a different schedule. And then create a proposed holiday schedule. For holidays, a lot of parents will alternate every other year. So like in odd years, 2023, mom will have Thanksgiving, and in even years, dad will have Thanksgiving. So you can look to alternate holidays if you want, or you can say, mom always has Thanksgiving and dad always has Christmas Day. Like, you really just want to look at your family, the traditions, and what's best for your children. Also with holidays, you want to focus on how much back and forth does my holiday schedule require of the kids? And is that best for them? Are they just going to open their Christmas presents and now I'm going to have to take them to their dad's? That probably isn't going to be the easiest transition. So kind of really thinking these details through. And like I said, some people don't deviate for the holidays. They just say, we're going to keep following the regular schedule, and they'll fall where they may. And if one parent doesn't get the exact holiday, well, they can celebrate that holiday during their parenting time, of course, just not on the exact holiday day. So keep in mind that you do have a lot of flexibility here. All right, we come up to the end of the slides here. Let's do a quick summary. For legal decision-making, again, it's more narrow than most people think. We're looking at education, healthcare, religious training, and personal care decisions. And you can have sole or joint decision-making on those issues. If you want sole decision-making, you'll need to justify that if your co-parent isn't in agreement. And that can be justified by showing substance abuse, domestic violence and child abuse, a sex offense, sexual assault. And you can agree to one parent having final say if co-parents reach an impasse, or naming a neutral third party to make a decision, such as a doctor. So you can have joint, but if you reach an impasse, have one parent decide, or you can have joint, and if you reach an impasse, have a third party. That's not the court, make the final decision. Creating a year-long parenting proposal. So you want it to be detailed, you want it to be a year long, you want to have exchange times and locations, how you'll communicate. Create your proposed school schedule. What happens during 3-day weekends? What happens during fall break, spring break, and winter break? Who has the child? What's the exchange time? What's the exchange location? Does it stay the same every year, or does it change where mom gets fall break in even years, dad gets it in odds? Are you going to alternate? Create a summer schedule. This can be the same as the school schedule or different. And then create a proposed holiday schedule. It can be a separate schedule, or you can just let the holidays fall where they may during the regular parenting schedule. So we have a question about parenting coordinators instead of a judge. Yeah, parenting coordinators can help the parties to resolve issues and get on the right path. Ultimately, if you're not able to reach an agreement, you can still bring it to the judge for a final decision, and the parenting coordinator can render an opinion. But ultimately, Billy and I on the last live Q&A, we talked about this for a while, but yeah, I think you really just need to evaluate your case individually, see what your options are for a parenting coordinator. Okay, that brings us to the end of our slides.